Kumar v. Garland at the end of November, actually, November 30th, in the Ninth Circuit. Not so interesting. It's a pretty standard adverse credibility from India type thing. And it's interesting because it shows what the Alam v. Garland and Bonk decision from a couple months ago in the Ninth Circuit appears to be doing to adverse credibility, which also goes to USCIS credibility as well. And that is in Alam, the Ninth Circuit and Bonk held that all its prior holdings no longer good law in light of the Real ID Act, which came out a long time ago. All adverse credibility must be based on the totality of the circumstances. It can't just be like one thing and honing in on it without considering all the factors in totality. And so with Mr. Kumar, where the IJ relied on 3 or 4 inconsistencies and problems, and the Ninth Circuit only vacated like 2 of them. So there's 2 or 3. So there's at least one inconsistency that wasn't minor in Mr. Kumar's case. And usually that would have tanked his petition for review and it would have tanked his asylum case. But after Alam, the Ninth Circuit is saying, well, totality of the circumstances means everything. We've just vacated a couple of your reasons, so you got to do it again. You got to tell us whether under the totality, now that we vacated these other things, whether this adverse credibility finding stands. And that's a big deal. With a case like Kumar, in no way was a slam dunk adverse credibility challenge, which is really hard to do anyway. Mm-hmm. And so with appeals to the BIA and to the Ninth Circuit, I mean, Alam v. Garland does seem to be a groundbreaker for adverse credibility challenges because totality means everything. And if you chip away at one thing, maybe it all needs to be done over again, because how can you do the totality when the lower court relied on something that is now deemed to be insufficient?
Well, for a case like this, or a person's in removal, and this is just practice and money kind of stuff, like how do people pull off challenging and moving this up all the way to the circuit and then have to go back? Are these usually, because you guys deal with these wealthier clients, where they just get the money together? Is it pro bono? How do you see people be able to financially afford this?
No, that's a big problem. I don't have an answer. It's a big problem. It costs a lot of money to keep doing this. Some of these entities that do these cases are nonprofit, or they charge a flat fee to go to the petition for review stage. They maybe charge less than us, but no, it's a big problem. Don't get me wrong. Sometimes we do pro bono. We've done a lot of pro bono in the last couple of years as well, but that is an issue. You can litigate the client to just giving up because they just don't want to fight anymore.
Yeah, so when I hear these kind of cases, especially in the asylum context, people have like immigration issues and a lot of circus decisions. Like how did they force this up? Keep pushing it up like that?
Yeah.
There's a lot of cases where you just file appeal just to do it, and you bring nominal kind of paperwork and just pay the filing fee or something like that. But it's a big burden for people to challenge it. And so when you see it work, you're like, well, every case potentially could be argued. It really just comes down to you have the finances to be able to hear it out.
It's like very expensive to do. It's very hard to do petitions for reviews and make federal court argument. It's big leagues. That's an issue, absolutely. And how many valid, legitimate cases haven't made their way up to the circuits because people just can't afford it.
And it's the same with criminal context. Some people are in jail for stuff they didn't do. They can't get a DNA test or this and that. Kind of knocking the vice president's office in California. She tried to avoid people who had DNA tests that helped them out. She would challenge that as top prosecutor in the state. But this is a major issue for the innocent. We got to the whole system was made to protect the innocent on the Constitution, all that kind of stuff. But yeah, it's good that at least some of them are going through, because the totality circumstance situation is a hard one because it's so subjective. And even it goes back, the judge could, it's hard to argue with something that's so subjective, but at least there's some better, standards there that give people a fair shot.
And it's better than the case law in all the other circuits, where essentially one inconsistency will tank a case, even if the IJ relied on many.
Like I've had colleagues have asylum cases where just like half a sentence of something was off, just people were saying it in passing, and I was like, oh, you got one thing wrong, the whole thing is bad. Where it's like not realistic, for you to remember a million different things and know by the book the way they wanted some officers. So yeah, it's it really has to push the totality of circumstances. You got to be reasonable. I remember what I have for breakfast. Like it's it's hard to remember all these facts necessarily. So yeah, it's just a weird situation.
I was in a USAS interview recently where they asked the guy who was about my age whether he knew his non-citizen wife's what was his non-citizen wife's phone number. I'm like, I don't know my wife's phone number. It's I type in her name and the cell phone. That's an antiquated question. Like, who knows phone numbers?
They stopped. I used to force my clients to memorize it, but it's been a couple years, but they stopped asking because I think I used to. But
They asked it in LA.
In LA, really?
Yeah.
I used to make it mandatory, memorize the phone numbers, but in the emails too. But I stopped because I hadn't heard it being asked in a while. But that's interesting that they ask again. Yeah, it's not a reasonable question. Nobody knows. I only remember phone numbers from before we had cell phones. My mom's number and my sister's number. I learned my wife's number because we used to go to the gym together and have to sign off emergency releases, and so I have to memorize that. But other than that, it's just no way I'm gonna memorize the phone number.
It's nuts. Under your question, how do these things make it to the petition for review stage? The next case, Nasimba v. Attorney General of the U.S. out of the Third Circuit, is such a case. It looks like on petition for review, Mr. Nasimba was represented by Dwayne Morris, which is a big firm. So sometimes that's how,
Yeah.
they get there. And this is just a mic drop of a case for Congo asylum cases. And give it a read. Anyone who's got a Congolese asylum case, they got to read it. I mean, the quote, "It is beyond dispute that the Democratic Republic of Congo has a history, pattern, and practice of persecuting political objectors," end quote. And it's a huge quote. And
Yeah.
it's full of it. It's great on reasonable relocation, IJ's cherry picking the record, how physical harm isn't required. Um, all these things, really many of the points that DHS usually argues and that IJs often rely upon to deny, Third Circuit's going through it meticulously, saying why that is ridiculous.
And that
Um,
physical harm too. I've had friends say like they push him. It's like the threat of harm is enough. It's like what is? Isn't that the case where you don't have to have the physical harm?
it is threat of harm, and so that's always been the case for the future persecution. But if you establish past persecution, then the government has the burden to, and the burdens flip, and so you always want to be in past persecution territory. And there are some circuits, and now and including the third, very expressly here and before, that says even past persecution doesn't require physical harm
Mm.
under the right circumstances.
Yeah.
I mean, the 11th Circuit has said that not being able to practice one's own religion is a form of persecution. That's not physical.
Yeah.
So, this case is fantastic for a number of reasons. I highly recommend everybody listen to it or listen to the podcast episode where I try to quote as many things as possible that can be used in asylum cases. Walcott v. Garland. It was published on December 22nd. And this one is just absurdly complicated. I'm not going to get into it, but it's essentially about drug trafficking and whether it's a crime involving moral turpitude. And the case goes all through the Ninth Circuit's prior precedent, and the Ninth Circuit is distinguishing its precedent. And it is kind of fact specific based on the Arizona statute at issue. But at the end of the day, it did hold that this specific Arizona transport statute of less than 2 pounds of marijuana is not a CIMT, in part because less than 2 pounds has been deemed to mean as little as 3 joints. And so, it's a wide range, and you don't know if it's the 3 joints or the 2 pounds, and so it can't be turpitudinous. It's a complicated analysis, as it always is.
We're talking
Sure,
about.
no, it's about drug trafficking, and it's very complicated. It's about a specific Arizona statute, right? And it held that this specific Arizona statute is not a CIMT because it's transporting of 2 pounds or less of marijuana, and the way Arizona prosecutes it, it could be 2 or 3 joints, all the
Yeah.
way up to 2 pounds. And so, under the categorical approach, you don't know whether it's 2 pounds or 2 joints, and so that was one of the reasons it was held not to be a CIMT, and very
Interesting.
fact specific, and it's a primer on making these categorical approach arguments. But what I like from
But
the
it's really important right there because I thought like it's up to the petitioner or the applicant to be able to prove that. I didn't realize they could argue that. So that's going to be used widely in these kind of
it
cases.
depends, it depends. It's the realistic probability test, and it depends how it's being applied in all the circuits. And this is a whole podcast episode for another day, and I think it needs to go back to the Supreme Court. But even if we're talking about the realistic probability test, the applicant did prove it here. You don't have to prove it with your own case. It's with your own case or other cases. And here, Mr. Walcott, or Miss Walcott, I believe, found Arizona cases where it prosecutes 2 or 3 joints. And so that is sufficient to meet the realistic probability test. But very complicated issue. I believe that if the statute clearly is overbroad, that the realistic probability test has no role to play. And the Supreme Court in Duenas Alvarez, that is what they said there. But this is a whole nother conversation. But while I like Walcott so much, is because at the end of it, the Ninth Circuit says, I mean, just to paraphrase, essentially, societal attitudes towards marijuana are changing. And so because of that, the CIMT definition is changing. And in part because of that, transporting less than 2 pounds of marijuana is not a CIMT. And again, it's specific because it could have criminalized 2 or 3 joints. But
Yeah.
the greater point is good. And the court talks about Lawrence v. Texas and how sodomy used to be a CIMT. And then,
Yeah.
when case law changes, so too does the law. And the Ninth Circuit is poised to change the CIMT definition vis-a-vis marijuana because society is changing about marijuana.
That's a big deal. That the case statements are a big deal. Wow.
Yeah. So those are the 4 cases, the 4 case rundown in 20 minutes.
You did an excellent job. Kept my attention going through all of them perfect and perfectly prepared. Sometimes it's like, oh, this is getting too complicated for me. So I'll just say it for our viewers who need to know this stuff, but this is beyond me. But all of them were really interesting. It's been over a year you've had your podcast, right? It's been a
Oh
year.
yeah, May 2020. It's been over a year and a half.
Wonderful.
It's crazy. Next week will be episode 89, and that's not counting the 10 or so special episodes of interviews.
Yeah.
That's wild. It's a labor of love, as you know better than me, on episode 280 something or other.
225. We'll get to 280.
225. I'm sorry, 225.
Now, what have you? I mean, it's a new year. What has you gotten out of the podcast? Obviously, it's personal stuff, but have any interesting things happened or connections or things from 2021 in the podcast? Because
Oh my God, all the time. I mean, people reach out all the time, and I provide these self-certification CLE certificates. So people reach out for that, but people also reach out just to talk. When the Rodriguez v. Garland Fifth Circuit motion to reopen in absentia deficient NTA issue was percolating, and it's still percolating, I got like an immediate email from a listener talking about this is happening right now in a Texas immigration court, and this is how it's being applied. So I could convey that. No, I love it for how it enables me to talk to the greater community. I've been invited to speak at immigration events, and I really appreciate that, and I have a lot of fun. And my outline alone is 900 pages with all the cases. I'm working on a Fifth Circuit one right now, and so just for me personally, it's a giant case law brief bank for control find. I can be, wasn't there? I can be like Ira. Ira says, "Look in my book. I believe there was a case," which is just the worst thing that Ira Kurzban can say. But I'm like, wasn't there a case about marijuana in Arizona? I could swear, and then I can find it, in 30 seconds. And so
A lot of
it's
work to be able to prep that. I've tried doing that kind of stuff, and I have a library I've created for the toolbox, which I'm going to open up free once I clean it up a little bit.
yeah.
But I've just done videos where I have it because I'm like, that's the best way I could do is do title searches on videos in a library, but it's a lot of work. Have you ever been contacted from anyone from the government? You don't have to go too much into it, but any government officers contacting you?
I mean, look, I've pushed it to ICE trial attorneys. I'm aware that people at various ICE offices, USCIS, and at OIL are aware of the podcast. I don't know how many, but I know that they do, and I know that immigration judges, some, are aware of it. I don't know how much they listen, but so I mean, with that in mind, but even if it wasn't, I tried to be fair. I mean,
Yeah,
it is. I say it's not biased, and it's not biased legally, but of course it's there to try and provide a service for immigration respondents counsel, and to
hmm
push the envelope rather than to contract the envelope. Because
yeah.
what is the fun of being private bar if you can't push the legal envelope?